what he thinks in regard to the planning article of the charter and whether or not it should be in there or should be thrown out or whatever he desires to give us in way of input. Mr. Beatty?
Frank called me yesterday, so I haven't had much time to think about it. But I did take the 1971 charter and look at that, and I'm not convinced really that we do need an article in there on the planning. But after thinking about it, I'm not sure that it's going to hurt anything. So I did redraft that article, and this is what I thought. You know, the minimum shouldn't be in there. And really as a maximum. If you look at the 1971 charter, you'll notice I took out anything that changed the plans of the park. To me, it didn't seem that was necessary in there at all. What I've done here is really outline what should be in the comprehensive plan, and that comes out of our area-wide planning ordinance as well as state statute, and then also what the planning commission function and duties are, and that relates to some state law as well as our local ordinance. And I've changed some of the wording in the old 71 Act, but I think this really says all it needs to be said at this point in time with regard to planning and so on. It allows for the establishment of plating boards and boards of examiners in the fields and so on. The planning commission can delegate by state law, which they have.
You feel basically then that if it weren't in at all, you're still covered.
I think basically if none of this was in, the state law covers it pretty adequately, and then our area-wide planning ordinance, I don't know if you have this, and I don't know if you want it.
I'd like that.
I think that's a good deal.
This is an ordinance that we've got adopted here, which amplifies on the state law and tries to make it a little more explicit. Now, between the state law and this area-wide planning ordinance, we really have everything that I've got in this article, Article 6, covered. And I'm not sure whether, like I say, that's really needed to be repeated again here. I can't see any harm in it, however, putting it in this kind of a very general form, which allows us then to expand upon it in the form of our own local ordinances after the communication takes place.
Do you feel putting it in might raise a flag? Or?
I don't think so, not in this form. I think that's my opinion. You know, it's general enough that it should raise a flag, but at least it gives it a place in the organization.
This is what you're proposing here. This.
Mr. Chairman. Yeah, I did ask the other night, and that's what Bill was referring to, that the Planning Commission have an opportunity to respond, and I think we were able to schedule it on a work schedule about the 10th, so it might be a little after the commission's this commission's first action. But we did, in following up on what Fred said, receive specific testimony from the Whitsons that there would be such controversy, they felt, in the community due to the current comprehensive plan that they felt, that there would be a tie to this particular charter, and it would be very negative. And wasn't that basically
Yeah,
what
that's what was prompting me to bring that question up. The fact that there might be a tie to it.
It could also be positive. And for the Whitsons, it's negative. Nothing we can do to the Whitsons that would be positive. So a lot of other people, it would be positive.
Mr. Chairman, I did have one specific specific question. Bill, you brought the charter. Could you please take a look on page 10, under the article on finance? There's a section that calls for 6-year programs for public services, capital improvement, and fiscal policy. Responsibility of the mayor to put in a 6-year program for public or for capital improvement. You have referred in 603 in your planning commission section here that the commission shall make recommendations to the mayor and to the assembly, concerning the capital improvements program. You don't see any conflict there, do you? And you feel that's an appropriate procedure, that should be the responsibility? We don't know at this point whether there'll be a mayor as executive or a council, but you feel that should be their responsibility to prepare that
Yes,
plan?
I do. I don't think it should be part of the commission.
Okay.
Like I said, I've talked to people on my staff with regard to whether anything should be in there or not. And as far as I can see, it's not going to add or detract, in my opinion, to put it in. It's not necessary, I don't think. I really don't think it's necessary, because I think state law adequately covers everything that's in here. And certainly a local ordinance that would be adopted afterwards would certainly cover it. If you think it's going to be, a red flag, as you indicated, that would kind of create something negative towards the whole charter, and you left it out, I don't think that's
Well,
preferred.
the only thing I was thinking of, the same thing Alice was making a point on, that is someone who's got a poker out for the present plan or doesn't immediately ties it to this and says, oh, well, this is the railroad. Although the way this is written, it doesn't refer to any specific plan, it is general. This is any plan that the assembly shall adopt.
Holmes?
Mr. Chairman, after Bill has had a chance to comment, I think the Charter Production Subcommittee thought that if we heard from the attorney at the beginning of the meeting with some legal considerations about what has to be in the charter and what we don't have to have in the charter, that might make the task of dealing with the planning article a little bit easier, because we'd all
Good
have
point.
a framework of legal knowledge.
Good point. Why don't we do that?
So if,
I think
Bill,
that-
I was eating yogurt and missed the very first sentence. Do you have another commitment so that you're going to have to leave, or could you stay for a later discussion? With that,
That sounds excellent, and we'll ask Mr. Kerman.
Okay, thank you, Mr. Chairman. Let's see, we lawyers always have to figure out how much time is allotted to us, because such things are
$50 an hour.
compressible.
$50 an hour.
it's 16 and a half minutes.
Fair enough. Well, listen, I apologize to people who've already heard this spiel, but I will try to vary it somewhat. And what I want to do is not to exhaust the topic of local government law as it relates to home rule, but to try to marry the principles we're dealing with to the specific job of what we're going to write in this thing. The source materials that I gave you here, probably the key thing as far as a background is the summary of the cases. The glossary also may help to clarify matters. Some of the terms in the glossary are not wholly writ. They are adopted, or I put them in this form because in some cases the statute used this type of distinction. But more than anything else, I adopted certain terms just so that we would have a uniform reference, that we would all be meaning the same thing when we said limiting charter or executive power, this sort of thing. What I think I'll try to do is talk briefly about the sources and the nature of this home rule power, this thing we're implementing in the charter, and then look at the limitations where we will be limited in what we can do, and then briefly outline the implications for charter writing of those limitations. As you know, the basic thing that we have is the constitutional provision allowing for a home rule charter which can afford local government all powers not denied by law or charter. Now this in itself there are several types of home rule provision in state constitutions. And some courts have used a figure of speech that might help clarify it. Some states in their constitution provide what is known as a shield home rule power. Under this type of provision, the Constitution will say the municipality may adopt a home rule charter to govern local activities, or a home rule municipality may legislate on matters of local concern. This type of wording. What that does is sort of carve out a little chunk of subject matter where the municipality is supposed to be shielded from state interference or conflicting state provisions. Now, the one trouble with this is that every time the municipality enacts something, the question arises, more or less in the abstract, as to whether the exercise of municipal power is within this realm of local government activities. Even if there's no apparent conflict between what the municipality did and some state law, a plaintiff can say, look, this is not a local activity and therefore you can't do it. And it's, well, okay. The other type of provision which our court has, within which our court has said that Alaska falls, is the SWORD, called a SWORD provision. And the idea there is that the municipality may do things. It may go forward until it's stopped. And it is stopped not by an abstract category, local activity, as opposed to non-local activity. It is stopped only by confrontation with a specific superior authority of one sort or another. And we'll talk about what those superior authorities might be in a minute. Okay, now, so much for that. As we look at the limitations on what we can do, so we mentioned last time the provision in Title 29, the laundry list, so to speak, which spells out all those parts of Title 29 which act as a restriction on home rule municipalities insofar as acting other than the way the statute provides. So when we talk about state law doing this and state law doing that, that is useful. That's the first step. The second step is to see if the particular state law in question binds us, binds a home rule municipality. Okay, there are an example. I'll just try to tie these various limits, these various types of limitation. I will try to relate to some of the cases that have been decided. The last case in your collection there is Jefferson v. State. That, I suppose, is illustrative of a case where a specific provision within Title 29 prohibits what or conflicts with what the home rule municipality was trying to do. In that case, Wilkie sued to enjoin the transfer of the sewers from the city to the borough. And the reason for his suit, the basis for it, was that the Anchorage City Charter required a 3/5 vote of city voters before a municipal utility could be transferred. The borough, and incidentally the city in this case, said, no, that charter provision is overridden by the specific provision in Title 29, which says that no city within a borough, no city, whether home rule or not, within a borough may exercise an area-wide power, may continue to exercise a power, once that power has been assumed on an area-wide basis by the borough, which of course is what happened in the sewer. But anyway, that's just an example of a case where the home rule enactment was directly in conflict with the provision in Title 29. Now, I'm just thinking about the
Every Friday.
Every Friday
This
at
time.
11:30.
Okay.
The sky is falling.
Yeah.
30. Not my nose.
Okay. So
It's a
the,
big eater, and most of
I
them
was impressed by that.
so the search for limitations, or the possibility of limitations, however, doesn't end with Title 29. Other provisions of state law in other titles may specifically limit home rule municipalities. An example of that is, I think, this Schrock case that's in there. It was kind of a funny little case. All it involved was the city of Fairbanks attempted to impose a penalty for moving traffic violations, in addition to the penalties that were provided in the state statutes in the state motor vehicle code. And the state motor vehicle code specifically said that these provisions apply to home rule and to general law. And the court said, well, yeah, that's what it means, and therefore Fairbanks, even though home rule, can't add additional penalties. So we look to other statutes sometimes. A fairly obvious limitation on what we do, which has nevertheless been litigated, is the other provisions of the Alaska Constitution. In other words, we are, even though home rule, we are creatures of the state, and we are bound by the Alaska Constitution as much as anyone else. An example of that, I think, is the Juneau v. Hickson case, for instance, where Juneau wanted to sell bonds in order to buy land to give to the state, to encourage the state capital to remain in Juneau. And the state constitution provided that a city cannot sell bonds except for capital improvements. You cannot borrow money by selling bonds except for this purpose. And the court found that land acquisition for this purpose was not a, quote, public purpose. Juneau said, well, maybe so, but we're home rule, and therefore we're different. And the court said, no, the prohibition in the Constitution is of equal dignity with your home rule status, and you're covered. Finally, and this is probably the trickiest part of what we have to deal with, or what a home rule municipality has to deal with. The court has carved out some doctrines to deal with a problem that has come up, in fact. And basically the problem is this. Sometimes a state statute will seem to the court to be so basic and important to a state policy of some kind that it will be construed or deemed applicable to all municipalities, even though the statute does not specifically say so. The two cases on this point are the Chugach case and the Hildebrand case. In the Chugach case, the Public Utilities Commission granted a certificate of convenience and necessity to Chugach to operate within an area of the city. The city refused to give the building permits necessary to put up the poles and so forth to actually render the service, claiming that it was within the city's home rule prerogatives to enforce this ordinance regardless of the PUC's certificate. The court just said no. This was the beginning of the court's effort to find some way to accommodate this type of problem, and they just said, without a whole lot of theoretical underpinning, I guess, that this was the type of thing that was of statewide concern. And they adopted the so-called local activity rule as a way to provide some guidance in deciding what statutes will be accorded this overriding importance. Now, in adopting this rule, the court was criticized. Mary's seen this law review article by a guy named, I forget his name. Anyway, the court has been criticized in adopting the local activity rule And the authors, the critics have said, look, what you're doing is you're really putting us back into a shield type of home rule status, where every time we do something, somebody's going to say, well, that's not a local activity, and therefore you can't do it. We can discuss a little bit whether that's true or not in a minute. I don't think it's literally true, but there's some truth in it. The other case that recently dealt with the local activity rule is the Hildebrand case, which has to do with education. Of course, that becomes very important to us because there is concern as to what sort of leeway we have in defining the relation between the school board and the assembly. In Hildebrand, the assembly of Juneau, by ordinance, required a centralized accounting system with the school system and the borough. The statute says that the borough may require a centralized treasury if it wants to, but it may require centralized accounting only with the approval of the school board, and the school board didn't give its approval. Juneau said, we're home rule, therefore we can do this. Again, no specific reference in the state statute in question to home rule municipalities. The state statute sets out this series of little rules as to the relation between school boards and borough assemblies. It doesn't say applicable to home rule. Nevertheless, the court says that education is a statewide function. The Constitution says the legislature shall establish and maintain a system of schools. Consequently, the court finds that the statewide policy involved in this set of compromises outweighs the home rule powers of the borough. Now, say this is where we were as of the time we talked last, and up until November, say, when the Jefferson case came out, there had been some criticism of the court in cutting back on home rule powers, or apparently doing so. In the Jefferson case, the court did take occasion to discuss home rule at some length. It's a good case to read if you actually can get the case itself. It reiterated the sword nature of our home rule, distinguishing it from the shield, and it had some good language about the need for a definite conflict before the court would say that a home rule power was overridden. Now, the court did not overrule Chugach and Hildebrand. On the other hand, it did assert the fairly broad reach of Alaska home rule. What I read from this, the way I reconcile what they're doing, is that they are charting a middle course of some sort. They are not adopting the shield rule, which would provide that a home rule enactment could be stricken even in the absence of any conflict. Nor are they saying that the legislature must, in every case, say that a statute applies to home rule in order for that to be the case. The middle ground is that a home rule enactment is not invalid unless, one, it is in conflict with a statute specifically applicable to home rule, or two, it is in conflict with a statute so obviously embodying a state policy that they both can't exist. They both can't be given reasonable effect. Now, obviously, that's not a real crystal clear type of demarcation. And what you read from this, I think, is just a tone, some feeling on the part of the court that they do want to encourage home rule and give it as much scope as they feel it can in light of these other policies. Okay. Now, one thing that is important about home rule powers here. In federal law, in relations between state and federal law, frequently a system of federal law is said to preempt the field. The federal law may regulate very extensively in a particular area, and the states will be considered barred from that area altogether. Bankruptcy, for instance, is, I believe, an example. Our court rejected that theory as applied to the relation between home rule municipalities and states. An example of that, of the way that would work in Alaska, is the Ruby case. We discussed this before. This is a case where Fairbanks made assignation a crime by ordinance. And the defendant said, the state has already regulated extensively in the area of sex crimes and so forth, and that means that there's no room left for a municipality to get into the act. And the court said, no, we will not adopt that approach to determining the limits of home rule powers. And Fairbanks could go ahead and add to regulation of sexual conduct in this way. In the Jefferson case, the most recent case, the court reaffirmed its theory in Ruby. Okay, now I realize this is a lot of stuff thrown at you at once, and it's kind of abstract in a way. What I'll try to do is mention what implications I think these things have for the way the charter can be written, anyway, whether it should be. Before I do that, there is one other source of limitations for us that's pretty important, and that is the statute dealing with unification itself. As you know, that part of Title 29 which provides for unification says certain things about what must be in a charter and what has to happen by way of transition and so forth. Specifically, the question of spreading assets and liabilities is dealt with in the unification statute and will be applicable to us. And it says, for instance, that sewers, I forget the exact wording, but it deals specifically with the manner in which prior indebtedness for sewer systems has to be handled. And I believe it says that it cannot be spread even if the sewer is determined to be for the benefit of the whole area. So that's another source. Okay. Because we're a sword, we don't need to authorize anything. The charter really, I think, there's an exception to everything, but the charter does not really need to say the municipality may do this and it may do that. It can do anything subject to these third-party limits, kind of. It can do anything that is not dealt with or that we don't specifically prohibit in the charter. Therefore, we might decide not to put anything in the charter that says may, just as a way to shorten it. It's sort of a political question, possibly, whether the commission feels that certain things of that sort should be in order to express the commission's concern about an area. But as a legal matter, it is not necessary for the exercise of a particular power to say that we can. Now, the fact that we have these limits in the statutes and in the cases means at least one thing, means we should not put into the charter anything which is specifically in conflict with any of these limiting laws. That's obvious enough. Conversely, we don't want to tie, or we don't need to tie, the governmental powers under the charter to governmental powers as stated in the statutes or in any other source. In other words, we don't need to say that in the area of taxation, the municipality may do only what is provided in Title 29. even though the taxation provisions of Title 29 apply as far as they go at this point, we don't need to limit ourselves to the parameters of that statute for several reasons. One, under the Ruby type idea, we may be able to add to the provisions. Even though we cannot be in conflict with them, we may be able to extend them. Two, state law is subject to change, as you know, and if we key powers to a state of the law at a given time, we may have limited ourselves beyond what was necessary later on. Examples of these two things, I think, appear in the planning article of the charter last time. For instance, there is, as I recall, a statement in the planning article that the Commission shall have the powers prescribed by law together with additional powers provided by state law with respect to municipal planning and not prohibited by ordinance. By this, I think we would be getting on the coattails of state law in a way that we don't really need to do, because if there is a legitimate planning power to be exercised, the Assembly can exercise that power whether state law has mentioned it with respect to general law, municipalities or not. It's two different things. What the state decides general municipalities can do, general law, and what you decide this home rule municipality or the new Assembly should be able to do. The past provision also has some may language, I would say, where we say that modifications may be made by the borough or the Assembly with the assistance of the Planning Commission. No harm in these things, but it's not necessary. It can be done anyway. As Bill pointed out, if we don't put anything in this whole charter about planning, probably very little will be changed in fact in terms of the way the planning function is handled. Okay, ladies and gentlemen, I apologize for being a little sporadic about this. There's a lot to cover, and I'm handicapped by not knowing how much you already know, and I may have repeated some things unduly. What we might do is, if you like, take some time to look over the glossary and the summary of cases, and at a later time, questions, I'll be glad to try to clarify anything that I didn't reach.
Do we have any questions before we start going over the glossary?
Mr. Chairman, I wonder if his suggestion was that possibly that would come at a later time after we've had an opportunity to read the legal case and the glossary, or do you think it's pertinent right now?
Personally, I think it's useful to have people look the things over and think about it a little bit, formulate questions. I don't mind going over it now for the purpose of explaining things that appear at first blush.
In the interest of time and so forth, if we have time later on before 1 o'clock, why don't we do that? But I don't see anything on here that's necessary to the discussion of the planning article, so if we could move on to specifics, that would be my suggestion.
Any objection? Reading of the commission as a whole has been, as I understand it, to limit the extent of things in the charter to the barest minimum. And thinking on that basis, I like some opinion from the commission about
great concern of something being there, and politically it's well for something that we should keep it to the absolute barest.
Like, leave it at.
Yeah.
Juneau did that, by the way. Juneau doesn't have anything in its charter about planning.
Mr. Chairman? Rick, just so, on the material that you prepared regarding this, down below where you say attorney's suggestion, omit everything after the first sentence.
Okay.
Just could I be sure just what you're talking about is the first sentence there?
Yes, let me see, where are we here?
This is Article 6, planning on the legal side, and I believe that's from you, isn't it?
Yes, let me
That's
explain.
from the subcommittee.
Well,
You don't have to pay for it.
Do we have another?
don't we have some?
Yeah, I'd be glad to see the whole thing in the charter as far as the plan, if we could redo it. I don't like what they've done, but,
You don't like what?
I don't like the planning, but I think, if we put it in charter, I'd like to redo it all the way.
Redo what?
All the planning, redo all the zoning.
Oh,
Otherwise, leave it out, no zoning at all.
Anyone else need articles, this proposed article?
Carlos,
everything from 50 or 12 years ago is no good, right?
Up and including
Put a
now.
time limit on it.
sure. Rick, shall I explain what I did on this, or?
Well, yeah, or I can explain what the subcommittee did. And then
Okay, why don't I say what I did when I typed it, and you explain what we did the other night.
Fine.
I was stuck. I didn't have a secretary or anything. I typed this stuff up. Doing it as I believe the subcommittee ordained at the last meeting on this subject. Now, most of you may be familiar with legislative style type stuff. Basically, underlining means it's new, and bracketing with all caps means it's something old being taken out. The text is, as I recall, the decision. My little notes, I just put in there suggesting that the more I thought about it, the less I thought any of that was needed, and I put it for what it's worth, department. Now, as for the first sentence, I mean the first sentence in 603 there, after the word profit.
Oh, I see.
Just because I think that requirements to make recommendations are not terribly binding or basic.
Mr. Chairman, profit is the second sentence. Did you really mean after
Oh, for God's
ordinance?
sake, I'm sorry. All right.
Which?
That page, after the second one is what I meant. It doesn't pay to be your own typist, that's for sure.
Well, I'd agree after the first sentence.
Oh, okay.
Well, I got an interesting point on that one. We'll get to it.
Mr. Chairman,
Jerry?
Rick, does that explain everything you had in mind about your sitting down?
Yeah, I thought sure you could tell about what the subcommittee had thought on these things.
We listed planning as a major issue because we didn't feel as a subcommittee that we could resolve for the commission the basic idea, do we want to have anything in the charter about planning or nothing? And so I think the commission's going to have to make that decision, obviously, first of all. If there is something in, it would be the subcommittee's recommendation that it be as brief as possible. I thought that in addition we had put in 601A, the Assembly shall adopt by ordinance as a possible suggestion. In our discussion, we tried to think, if we had no planning article, would we wind up with a comprehensive plan? Or could we foresee another situation where a plan's written that's never adopted? I think the members of the subcommittee at least felt that a comprehensive plan was desirable to be mandated to our local government, and that there was a question of whether state law really covered a mandate of that sort.
Absolutely, question. State law requires you must have comprehensive.
But it doesn't apply to us
Why is that?
because it's not included in that list of parts of the municipal code which bind home rule municipalities.
So So as I understand it, there is nothing in state law that binds us in the planning field right now, is that
That's my
correct?
understanding, at least with respect to doing a comprehensive plan.
Or really with respect to a commission or an official map or zoning or any of those things?
I think that's,
Except maybe plating.
generally, I think that's true, sure.
So
Really?
Yes. Really?
We just went out of business, Arliss.
It's covered, Arliss, as I understand it, in the municipal code, but it doesn't say that home rule municipalities have to do anything with it. It's just for general law. But we can, but we're not mandated. So that in other words, the local government would be free to set up exactly the system that we have now, but they wouldn't have to. And we'd leave it, if we didn't put it in the charter, we'd leave it to the prerogative of the assembly to
That
decide
Well,
how
this
far they want it to go.
goes much further though then. I mean, there are quite a few constraints set by Title 29 having to do with planning, composition of the
But they
commission.
notify
And so you're
evidently
just
to
saying
local, to home rule municipalities. We're not covering that.
Have you covered sometime the things that are required in Title 29? I've read it through several times, but I don't remember what the things are, the home rule that we must
Yeah, Jane, there are 33 distinct parts of the municipal code that are in this section applicable directly to home rule. What I had planned to do was to take them as we went subject by subject and pick out those which did limit as to that subject.
There's nothing in there that binds home rule government to any kind of planning at all.
That is my understanding, yes.
Well, in that case, I think you are right.
Write it in.
We have to, if we aren't bound to do it in the state law. If it were in the state law that we had to, we could ignore it.
I had been operating, Mr. Chairman, under the misapprehension all along that the part of Title 29 dealing with planning was going to cover us, and so therefore, why did we say it all again, and in the interest of a simple charter, let's forget it. But it appears that that doesn't apply at all, and we might wind up with no planning commission, no comprehensive plan, none of that stuff.
You can see the theory. Planning within a municipality is deemed a local power. It's something that a home rule municipality can decide for itself.
That is not covered by the mandatory Borough Act. As one of the four functions of the mandatory Borough Act, education, planning and zoning.
Planning and zoning is covered, but not the adoption of the comprehensive plan by a planning commission.
Well, this is what I'm wondering now. Under Article 4, it sets forth the planning, platting, and zoning. And it gives all kinds of things. They'll provide for platting, planning, and zoning, the composition of the commission, what zoning is, what a comprehensive plan, sets forth specific procedures on boards of adjustment, judicial review, platting jurisdiction and power, all of those things. Are you saying that we are not bound by any of that?
Yes,
We are not.
yes, you're not.
That is incredible.
Aren't you
That's a big responsibility to be a
My
home
God.
rule municipality.
Therefore, we
You're
have a
on your own.
recommendation before.
You are covered under the general law.
Well,
Borough.
no.
I thought he's saying we are.
That's my understanding of the law now, but, Frank, it's just not in here as one of the things which is applicable to us. Now, it is conceivable, of course, that a court at some point would say, well, it's so important to the whole state that a big area like Anchorage be adequately planned.
Oh,
We-
our.
But planning and zoning is under the borough now,
That's right.
and under this applies to the borough, does it not?
Yes, as of now.
As of now, it is covered, but when we go home rule city, it would not be.
That's right. I mean,
Can we
the
do it
freedom,
by- Can we do it by reference?
sure.
Do what by reference?
Planning.
Can we insert in the charter by reference to Title 29 or whatever applicable law there is, rather than going into detail in our charter?
Well, you could,
Chairman, I understood the attorney to say that one of the disadvantages of that was that the thing you're referring to isn't stable and may change. But it also has the disadvantage that the reader of the charter doesn't know what is incorporated by reference.
you know,
I always think there's something being hidden from me. If they give me a reference, they don't tell me what it's about. And I guess I'm just downright too suspicious. I think that's what you'd accomplish by that effect, Frank.
you know, this,
Do you think that the feeling in the community is such that we said there shall be a planning authority and they shall advise the assembly on development of the comprehensive plan and left it to the assembly to look at the machinations that planning is important issue in this community that the assembly would define what you're doing is giving them the power, which is what the home rule says you're supposed to be doing.
it's, you know, this is an interesting,
It's partner.
This isn't with regard to exactly planning, but
Louder.
I was wondering,
Hey, that's good. Keep it up.
Been lying all the time.
under your definition of terms, you have limiting charter, and that's where you don't really go into detail. And then there's the granting and enabling charter where you go into more detail. Because so many of the things aren't spelled out for us, and we can go any which way or we can say nothing, what would you say would be the best way to go?
well, since I've been asked, I'll answer that if you like. You know, I think this question is good that it came up now because the home rule business is not just a freedom to do. It illustrates the point. What home rule also confers to some extent is a freedom not to do. And in some cases that may be more scary than the freedom to take parts and steps. My own feeling is that if the charter had a very simple, somewhat along the lines of what I noted in this draft you have, under 601 I would put in, say, subparagraph A, the Assembly shall adopt a comprehensive plan. Okay. And possibly I would leave in all of 02 as it is. The Assembly shall by ordinance adopt land use and zoning regulations, including a map. And 3, the first two sentences of section 603, which just says there shall be a planning commission, and its duties shall be specified by ordinance and so forth. And I would omit the rest of the language as detail.
Mr. Chairman, I think that was basically consistent with the discussion in the subcommittee the other day. We did not want, without hearing from Mr. Beatty and from the rest of the commission, to suggest taking out 601B and C, but we questioned whether it was really necessary. And I would concur personally with Rick's suggestions, and I would wonder, even if we needed the members of the Planning Commission shall hold no other elected municipal office or position of office, whether that might not be covered in a different place in the charter under members of one municipal office shall not hold other municipal offices. I wonder if it really is necessary to put it specifically under planning.
Frank, excuse me, I have to leave. I had a prior lunch today. It's almost frightening to leave. I'm afraid, but I've given my proxy to
Instruction guard, I'm sorry, one sentence or
Sorry
nothing.
to,
yeah.
you've been so short.
Little or none, yeah.
So, thank you for being here.
Good. See you
Mr.
on
Chairman,
Monday.
what was the point in putting that second sentence in there? There must have been a reason. Why was it added? In view of what Sherry has said.
You want to answer that, Sherry?
Fred, there was a similar sentence in the charter the last time referring to members of the planning commission shall hold no other municipal office. And we felt if you left that sentence in, the term municipal office should be clarified, whether appointed, elective. We didn't want to restrict it to members of advisory boards. You know, we didn't want to make being a planning commissioner absolutely the only thing you could do. But we wanted to.
So actually, if you're going to have some other place in the charter, there's really no need of having it here, then, is there?
I would think that would
If you want to adopt a general rule
Yeah,
as
a
to
general rule that applies
rule
all
office
through the
holder.
charter.
Mr. Chairman, we have a specific example that comes to mind. There's an employee of the city who deals with engineering and rights of way and so on, who is also a member and receives salary of the planning board. Now, I see a basic conflict in the type of work that he does, really sitting on both sides of the fence, protecting the public interest as well as his own personal interest. And I would like to see, I think it could resolve some sticky problems for the municipality on down the line, and in effect gets into the conflict of interest in certain areas.
That should be separately set
But it
out.
doesn't, I can't see any reason why it has to be.
Applicable to all the offices.
I don't, but not advisory, those advisory boards.
I don't think
that
it should extend that far.
No.
That was the intent of this wording, was to exclude advisory by making it elective or money.
We might still, Mr. Chairman, consider this wording as a possibility for a different section of the charter, a different article.
Mr. Chairman, I think it should be in a different section.
Separate section.
That second sentence,
Yes, because I think it applies to, I think it applies to school boards and assemblies, and I think it applies to any other commission or advisory board where we are paying a fee for their attached.
Mr. Chairman, if it's appropriate at this time, I'd offer a motion that we have a planning article in the charter, and that the planning article include section 601A, 602, and the first sentence of 603.
Second.
Moved and seconded. Moved by Ms. Holmes, seconded by who seconded?
Mr. Chairman, to clarify that, I had written in section 601A the words by ordinance, which we had intended to be in that.
After the word adopt,
Shall adopt by ordinance. I do want to discuss that.
601A, including the words by ordinance.
Shall adopt by ordinance.
Shall adopt by ordinance.
I'd like to hear from Mr. Beatty at some point on that.
I would agree with that.
I like this.
Lady, have you any comment on that?
The only comment I have on that particular thing is that I like my wording better on item A. I think it gives a little more clarification as to what the comprehensive plan should do than the old wording under the old charter. I think the word by ordinance ought to be added, but this spells out a little more detail what a comprehensive plan should include in the old charter, the wording in the old charter.
Well, Mr. Chairman, essentially, we could accomplish that by approving the motion of Mrs. Holmes with the addition of the goals and objectives reference. Would you object to that?
I would not object to the addition of the goals and objectives reference. What I question is and its administrative practices,
That confuses me.
whether that would refer to any administrative practice of any part of the entire administration or merely with reference to planning.
Well, what we meant here was administrative practices relative to land use decisions. well, matters covered in the comprehensive plan, let's put it that way.
Mr. Chairman, I wonder how the courts might interpret that phrase, municipalities and its administrative practice in terms of construction. That's exactly the point that seems like a sleeper, or could be interpreted as a sleeper.
Let's ask Mr. Burnett, what do you think about that?
I would think it should be made specific just on general principles. Why have vagueness when you can have specificity? No.
I'm not sure that it's necessary to put that in. I think that is something that follows from what we mandate of the Assembly. That it's in order to accomplish what we've set forth in the first part of that, you have to include the practices.
Then I would move to amend Mrs. Holmes' motion by inserting the term about the words goals, comma, objectives, and before the word policies.
Goals, I'm not sure that I follow you.
So that 601A would read, the Assembly shall adopt by ordinance, from time to time modify a comprehensive plan setting forth goals, objectives, and policies governing future development of the municipality.
I'll second that, or was there a second?
There was no
There was.
I,
Is that acceptable to
Chairman,
the main motion? Is that change acceptable to the main motion?
That is acceptable to me, but I think
And do you,
procedurally,
Mr. Chairman, just procedurally, I think you should call for a vote on that, and then it becomes the main motion.
Mr. Chairman, I'd like to do a little discussing before we go to a vote.
All right. Then the question would then be, if I read this correctly, that we should adopt, we should include in the Charter 601A as change, adding by ordinance and by adding after adopt and adding after setting forth in the second line goals and objectives and policies.
goals, comma, objectives,
And policies.
No,
Well, policies, right, yeah.
And policies governing all 602
Mr. Chairman,
in the first sentence.
no, what we have before us now is an amendment to 601A, and so it's the amendment that's before us. It's merely the adding of the words of to in section A,
Goals, comma, objectives, and
right, and also by ordinance
By ordinance.
after adopt. So that's the narrow question that we have now.
is there further discussion on that?
I would like to ask some questions. I was under the impression that the comprehensive plan included goals, objectives, and general policies. And inasmuch as I have been hearing that the goals as published in the newspaper were felt so broad that folks, quite a number, were scared of them, that I would like to avoid mentioning them if they're included in the comprehensive plan. If that is included in the comprehensive plan otherwise. Yes, I'd like to.
Look what happened, then you can draw a comprehensive plan. And I've seen comprehensive plans that have no mention of goals or objectives.
And I think it's important to have them.
Mr. Chairman, for just the sake of discussion, we might consider just saying comprehensive plan governing the future development of the municipality and not make reference at all to what we feel like should be in a comprehensive plan. That would be the other extreme.
Mr. Joseph?
That also but I really think that the language should be changed to stick to the format unless we go to what Mrs. Holmes just said. The language should include references to goals so that it's clear to those who, after all, if we're putting this in partly because some people want to be sure there's no, that our concept of it is as comprehensive as theirs. The reference to goals is in the existing statute. The nation, I think, there's more knowledgeable than I here, but the plan is that it does set out the direction, tone, movement of the community, as well as its policies, which may be more static.
Mr. Chairman, I do subscribe to placing it in. I think what Mary is raising is possibly raised by the witnesses for us, but we have
Not them, I've heard it other places.
tremendous number of people in this community now who really are interested in planning, and I think that we would have a far greater response from those who recognize almost as a policy statement that we are concerned about these areas and in essence mandating them, and I think we gain more support than less if we
I do too, but, and I want us to have goals and objectives in it, but my question was, is it necessarily included if we don't include it? And he's answered that question. If it isn't necessarily included, if we don't include it, then for goodness sakes, let's include it.
Further discussion?
As a point of clarification, once we've made an amendment to this first section, can we make another amendment?
Amendment to the amendment?
sure, but I think it would be possibly appropriate to take action.
All right, any further questions? All those in favor of the amendment on 601A, adding by ordinance and adding goals, objectives, and
Do we still have the policies governing the future development? All right. All right.
How would you like us to vote? Right.
I think probably it'd be just as easy to have a hand vote. This, on all those in favor?
I think I'm for it if I know what's there. That is out.
It's by ordinance and then to add for goals, objectives, and that's all.
Okay.
Yes. Those opposed? Are you opposed or in favor?
I was for it. I was for it.
Just got our hand
Mr.
up.
Chairman,
Ms. Parker?
I'd offer another amendment on 601A after by ordinance and from time to time reevaluate instead of modify.
You reevaluate.
Yes.
I'll second it for purposes of discussion.
Moved by Ms. Parker, seconded by Mrs. Sturgis.
Mr. Chairman,
To change the word modify to reevaluate in 601A. Mr. Chai?
modify denotes an action. Reevaluate necessarily doesn't mean taking an action.
Maybe an action doesn't need to be taken though. You know, you can go in and you can modify it, maybe you're modifying it and you're going to mess up everything.
Well, that can be true, but why limit yourself? I mean, why not take it up to the point where if you want to modify, you can. If you want to stop reevaluating, fine, but you still have the privilege of going ahead and modifying something.
But if you reevaluate, you can still modify.
Mrs. Holmes?
We're in semantics.
It appears to me that we've been so vague in this little phrase, and from time to time, modify or reevaluate, that it really is not going to make a substantial difference in what action we're mandating the assembly to take. It's just, I think, a matter of language looks
Well,
nicer.
To one in general public, it would appear to me that the word modify connotes action. The word reevaluate is a bureaucratic word where somebody reads something and they're going to staff it, reevaluate it, and staff it again. When you say I'm going to modify something, you're taking an action. I think the public would buy that more readily than they would something bureaucratic.
Mr. Chairman, to me, reevaluate connotes thinking about it, and modifying doesn't necessarily, but that is maybe just my...
Where's Donna Matthews, who knows every nuance about every word in the world?
Joseph? Is there any other comment?
Question.
Question's been called. Use a hand vote to add to or change the word modify to reevaluate in 601A.
Please keep your hands up long enough to be counted.
I'll go aye. Reevaluate?
Reevaluate.
Was your hand up, Mr.
Yes. Those opposed? We're short one vote.
It's me, I don't care, either way suits me.
You gotta vote.
Supposed to vote.
According to our rules of procedure.
They choose me on that once already.
All right, and now back up for the reevaluate.
4.
My count is 4 and 4, Mr. Chairman.
You can't change your vote. Did you get it? I think we're tied.
You got a tie vote.
Tie vote.
Who'll break it?
That, well, tie vote. Motion loses.
But there's 9 people.
So the motion has lost.
Mr. Chairman, I count 9 people.
Yeah, I'm good.
2, 4, 6, 8, 9.
There's only 8
Yeah, but 8
No,
votes. The chairman,
There's 9 of us, you can't have a tie vote.
That's right.
Yeah, can you count again?
I didn't count.
No. And you voted.
All those, let's do it again.
Yeah.
Okay, all those in favor?
All those in favor?
Reevaluate.
4.
2, 3,
Those opposed?
1, 2,
5.
5,
Motion is lost. Sorry.
We're
Miscounted.
Now,
The main motion now is in front of us as changed by amendment. The main motion was to adopt the Florida Charter 601A as amended, 602, and the first sentence of 603.
Mr. Chairman, I believe the main motion was, in addition, that we have an article in the charter concerning planning, and then that article includes.
yeah, move to have a planning article in the charter, and it includes 601A and 602, and the first sentence of 603.
Mr. Chairman, I would move to amend for section 602 to substitute the words submitted by Mr. Beatty.
That then would change to the Assembly shall by ordinance adopt land use zoning and subdivision regulations which shall include an official zoning map, a zoning ordinance, and a subdivision ordinance. These maps and ordinances shall serve to implement the comprehensive plan.
I have one question,
Mayor
Mr.
Cronin.
Chairman. Shouldn't there be a official roads map, a roads thing in there as well, Bill?
Mr. Chairman, I don't think you really have to spell that out specifically in here. That really is normally part of the comprehensive plan, and I don't think it has to be put in.
Was there a second to the,
I will second it.
seconded by Mary Cronin, moved by Arlen?
Mr. Chairman, I have some question as to whether we need to have, it calls for an official zoning map, whether we specifically need, say, the zoning ordinance and the subdivision ordinance. I think the key in there, though, is that these maps and ordinances shall serve to implement the comprehensive plan. And I think here, again, you're getting into the area of really a major policy area where you're saying you will pay attention to planning and a comp plan, and you will direct the actions to make that plan really work. And it's what happened before, where we never adopted it, the 1980 plan, and the policies that followed, of course, never carried it on. And so it's kind of a policy statement. But I question whether we would need to add the zoning ordinance and subdivision ordinance.
Ms. Barger?
Mr. Beatty, what is the difference between zoning and subdivision ordinances?
Well, subdivision ordinance applied to the subdividing of land, whereas zoning ordinance applies really to what you can do with that land, regardless of how it's subdivided. The zoning ordinance does not cover in itself subdivision regulation.
So they're two distinct.
Two very distinct things. In fact, we have two very distinct boards accomplishing it.
Yeah, but that's not necessary.
Mr. Chairman, is it correct to, as I understand it, this section would refer to regulations, including ordinances, is that correct, or that's just a reiteration? I mean, the regulations just tracking the ordinances adopted by the citizens.
I'm not sure that.
Well, it says that the assembly shall by ordinance adopt land use zoning and, I see, subdivision regulations. I guess I'm confused by the terminology that by ordinance they adopt regulations. By ordinance you adopt ordinances. And I thought regulations were something
Same
different.
thing I read.
Yeah.
I see. Do you see that, Bill?
Well, we call
Paul?
the subdivision regulation as the main thing.
Chairman? I'm getting the feeling we're getting mighty specific.
Yeah.
That we're getting too much garbage.
Yes. Yes, Jim, you're right.
No on anything.
Better back.
I see land use as a broad category which includes subdivision regulations and a zoning. And I see the zoning ordinance as being covered by the wording in the main motion. The only thing that I would be in favor of adding would be a reference to the comprehensive plan. I think that has merit, perhaps, that we wish to serve the legislative body with notice that we expect these things to be done in concurrence with the comprehensive plan.
I think that Sherry's got a point. My feeling is that we could say land use is very broad, but I would like to specify a zoning ordinance and a subdivision ordinance, which would be used to implement the comprehensive plan.
Mr. Chairman? This again refers to some of the discussion we've had previously. The comprehensive plan is a pejorative term in some people's mind and will be taken up as a cudgel to a club and used by some as a pro or con kind of an argument. And I wonder if we will be advantaged or disadvantaged by its inclusion. I understand what's being said in terms of its implementation. We've had 15 years of talk since that 1960 layout of that thing that never has occurred.
What about
Barker?
Yeah?
I want to ask Mr. Beatty if zoning regulations and ordinances and subdivision regulations and ordinances are different things, and they require different things, don't they?
They're
And
entirely different.
If subdivision regulations were and ordinance were left out of this, well, when were they implemented, and what happened before they were implemented with regard to subdivisions?
There were regulations. They were, of course, sadly out of date, but they did exist.
Mr. Chairman, I really like the language in Mrs. Holmes' motion. One of the reasons is that the existing statute concerning comprehensive plans refers to the comprehensive plan as a compilation of many things and may include, but is not limited to, statements of policies, goals, standards, land use plan, community facilities plan, transportation plan, and recommendations for plan implementation. Now,
Where's that?
I'm looking at the state statute. Now, I understand that that wouldn't bind the home rule community, but the point I'm making is that the best concept of a comprehensive plan includes those elements, and I'm fearful that if we say that we're going to have a comprehensive plan which is implemented by subdivision ordinance and zoning ordinance and official zoning map, that we're getting down to a kind of planning that is very land use oriented instead of a really comprehensive plan which involves community facilities, transportation, and these other attributes. And for that reason, I would rather steer away from that and use the language we have, in addition to the fact that the language in the motion is shorter.
I concur with that.
Mr. Chairman, I'd like to further reiterate, I just looked back up to Section A, and I think that Section A already covers that sentence.
602, it takes care of 602 altogether, doesn't it?
Yeah.
Yeah.
Can't we just leave 602 out?
Well,
Can we think of any situation where this would be misconstrued or where I want to go back to Lisa's philosophy question, which is this a living document or a power document, and are we interested in giving the Assembly the power to make the decisions, and do we have enough faith in an elected body to do that, to reflect some of the concerns that have been expressed here this morning? If so, if we do have faith in that Assembly to be able to recognize that they need a subdivision ordinance and they need a zoning ordinance, then we don't have to tell them to do that. If there's a question about whether or not we do have faith in the Assembly to be able to do that, then we're talking about a second-class borough instead of a home rule charter. And maybe we ought to talk just a little bit about that among ourselves first.
All right, let me ask a question here in relation to this. Could we add a little bit to that first sentence that we adopted up there in A? That they shall by ordinance serve to implement the comprehensive plan.
who said that?
That they,
No, she said serve to implement,
that
not
they
just
will-
to adopt.
that they shall adopt
And implement by ordinance.
and implement by ordinance. Shall adopt and implement the ordinance up here, from time to time modify the comprehensive plan. In other words, get the implication of implementing as well as adopting in that first sentence.
Mr. Chairman, when it says policies, aren't those implementations?
No, I think
That doesn't, policies aren't always spoken to by,
Policies is an implementing tool.
yeah.
You implement when you have a policy. You're directing something, so you're implementing something.
Phraseology is great. Jane?
Yeah, I would support Mary's suggestion on the basis that I have enough faith in that Assembly to be able to figure out that means they do those ordinances. And again, in lieu of everything that most people ran on as far as a short, concise charter, I would think just the word implement would be enough to say you have to put these things together.
Jai?
If we say the Assembly shall adopt by ordinance, isn't that all encompassing? I mean, do we have to go any further? I mean, why get so specific as to start putting words in? We're saying they shall adopt. That's all encompassing when they adopt something.
Well, but, Mr. Chairman, I can
It
see
isn't.
the
I'm sorry.
concern that
Huh?
that we might adopt a document which says that the mountains of Anchorage are pretty, and a very broad statement that does not get down to implementation.
Mr. Joseph?
Let me just think out loud and ask Mr. Garnett to comment. If you have a comprehensive plan, assuming that it has enough detail that it's a meaningful document about land use, and then you adopted a zoning ordinance which was inconsistent with the plan, what is your status then? Do you have to go back and amend the comprehensive plan so that the two are in conformity? Or does the court consider that the zoning ordinance being later adopted prevails? What happens?
No, Joe, I see your question, and I don't know the answer. I think the question is whether a comprehensive plan is legally self-executing in some sense. So that,
May I?
and I don't think it is, but that's my...
No, I
May I
don't.
comment on this in relation to the case that the Halo folks took the borough to court on in relation to the proposed comprehensive plan? As we understand what happened or what the court said, and I don't have the word ruling on it, the minute a comprehensive plan is adopted, then future zoning must conform with the comprehensive plan. But that does not necessarily mean that the Assembly has to go back immediately and make the zoning that is presently there, that was of a temporary nature until a comprehensive plan was adopted, that it does not necessarily have to go back immediately and make it conform to the comprehensive plan. And if we say implement here, as I understand it, that would make the Assembly go back and make their everything else conform to it. I maybe have not worded it properly to get that legally done, but that's what I would, that would be my intent.
Well, Mr. Chairman, that discussion goes to the point of this amendment, and I think indicates that the amendment is not necessary. Look at that prospectively, at least. Once the comprehensive plan is adopted, assuming it is substantively what I think most of us contemplate it to be, then it's almost redundant to say that any subdivision and land use and zoning regulation maps approved by the Assembly must implement the comprehensive plan, because they would either have to implement the plan, or the plan would have to be modified to adjust to them. Is that right?
See, Joe, if I were asked to give a definitive sort of legal answer on the effect of a comprehensive plan in relation to subsequent zoning and so forth, I would want to take a little while and check a few things out, because I don't have personal knowledge that I'm secure with at this point.
But you're not prepared to say I'm wrong, right?
That's right.
Chairman, let me throw out this thought, and it just occurred to me. We're writing a charter for 20 years from now as well as 5 years from now. What if 20 years from now zoning as a tool is not what we want? I mean, what if another thing is found that's better for controlling land use in this area? Don't we, if we have reference to zoning regulations, zoning maps, zoning ordinances, don't we limit ourselves more than maybe we necessarily want to limit the future government? And in that respect, I think I might support shall adopt and implement and delete all of section 602.
That also was part of my feeling. I'm not sure that those will be necessarily the names of the tools that we'll want to use sometime in the future.
Well, I think we have a parliamentary question now. The amendment pending is Mrs. Sturgill-Liskey's to add language to 602.
That's right.
Mr. Chairman, I would call for the question on that and state my intention not to support my own.
Can you repeat that?
Well, it's one by substitution, amendment by substitution, which would have replaced the wording of 602 that's supplied by Mr. Beatty.
Or you like
I don't intend to support it either, and I
Well,
was the second.
The Assembly shall by ordinance adopt land use, zoning, and subdivision regulations which shall include an official zoning map, a zoning ordinance, et cetera.
Right.
Okay.
All, is there
Question?
any question has been called for? All those in favor, by hand. Those opposed?
You're agreed. Mr. Chairman, I would like to request that Vic do a little bit of looking at that case and any others that Roger Holmes or Gary could refer him to in relation to the cases that have gone on the comprehensive plan so far.
Jane?
As a practical consideration, I'd just say that the Assembly can really go right ahead and adopt a comprehensive plan, but that the things that make a plan alive or not are the implementation measures that follow, which are all going to have to be ordinances and go, examining the fine-tooth comb. And I strongly urge that the word implementation be, well, hell, I'll move it. I move that we amend this section to read adopt and implement.
And does that, your motion include anything regarding section 602?
No.
That's in 601A. We're putting it back up to
601A.
601.
I second the motion.
Moved by Ms. Angrick and seconded by Mr. Josephson that we add and implement
For ordinance, before that.
before by ordinance and after adopt in the first line.
I think that may take care of it, but if Rick comes back to us with some better wording, I would
We can change it later.
be willing to
Is there
reconsider.
any discussion?
Does the adoption of the amendment or Mr. Garnett's research go to whether we retain 602?
No, we haven't come up with that. You are, I'll include, we dropped 602.
Yes.
That's my part of your amendment.
All right, I'm sorry, I didn't catch the second. Okay, the motion now is to include in 601A and implement, right, to drop section 602.
Drop.
602 altogether.
No.
Who seconded that? Joe.
Mr. Josephson. Is there any further discussion?
Can we ask Mr. Beatty about his feelings about it?
How's that?
Can we ask Mr. Beatty about his feelings about it since he's
I think that
a
makes a lot,
professional in
I
this?
think that makes sense. Because of the thing Sherry brought up, I thought about just tweaks it before you did, and that is that of all the things that may go in the future would be zoning, subdivision regulations may stay around for some time, but zoning may go per se. We may have some other form of regulation. That's why we put the word land use regulation to cover that situation. So I think that dropping the 602 is probably a good idea.
Any further discussion?
Yes, I'm not totally sure. Are we saying to adopt by ordinance and implement, or to adopt and implement by ordinance?
And implement by ordinance.
Thank you.
Any further discussion?
Question?
Question's been called for. All those in favor of the amendment? Those opposed? Everybody's in favor.
Mr. Chairman, I have a comment.
Ms. Angry?
That made that English just a little bit awkward. I hope Rick will look at that.
Just thinking about that. We don't know. Adopt and implement are both governed by ordinance or what?
Yeah, both should be governed by ordinance. But I think it does make the completion sentence a little bit awkward. Please come up with a better one.
Like
We
the
could say
Assembly
shall by
by
ordinance adopt and implement.
Ms. Angry?
Yeah, I'd like to propose another amendment to section 603. After the sentence, there shall be planning commission constituted as provided by ordinance. Oops. I just wanted to make sure that their duties are specified by ordinance.
Shall we?
Where does it say that?
Wait.
Constituted as provided. Oh, it just says,
I'll mention it.
I must have missed something, Jane.
You didn't say it.
I'm thinking out loud on Fourth Street.
What was your first
my-
statement again?
My concern is that we say all the stuff that follows will be dictated by ordinance, what their duties are. So,
Well, there was some talk, the way the amendment is, as I understand, or the wording is, that it's just that first sentence. That's all we have before.
yeah, and I just want to say that they not only come into being by ordinance, but that their duties are specified. That would probably be taken care of by that first sentence.
I don't think, Mr. Chairman, that they're likely to put a planning commission into effect without delegate them blanket powers to do anything they want.
Mr. Chairman, forget that I said it.
Mr. Chairman, as a technical sort of a adjustment to Section 601A, do I gather it's the consensus that the wording should be the assembly by ordinance shall adopt? That way we make it adopt and implement. That way we avoid splitting the verb and we...
That's better.
That's cleaning up.
I think that's merely cleaning up language.
What do we got on the table now?
We have, yes, we have the main original motion, which was to adopt Section 601A, and that's been amended to eliminate 602, which, so Section 603 would now become 602 and would be, we would be adopting 601, reading as follows. A, the assembly by ordinance shall adopt and implement, and from time to time, did we go modify? Modify a comprehensive plan setting forth goals, objectives, and policies governing the future development of the municipality. And 602 would now become Planning Commission. There shall be a Planning Commission constituted as provided by ordinance.
Mr. Chairman, all I can say, it is terribly scary, but it is terribly full also of opportunity. And it's both ways. You fought to get things through the legislature, but on the other hand, that nice protection that exists by state law isn't there anymore. So,
My only objection is that it shouldn't be 601A anymore. It should be just 601, right?
All right, 601.
Thank you.
That's editing kind of
I'm just getting started on this.
Is there further discussion?
I redlined those things.
Good day's work.
Question has been called for. All those in favor? Opposed? One opposed, Ms. Parsons.
scary.
Carlos, don't panic.
Mr. Chairman, wonder for Mr. Beatty, do you see a problem in taking this back to the commission? Would it assist to have Mr. Barnett on hand, or I suppose this since we've been through it?
So that I'm scared.
Well, I think we have accomplished a whale of a lot in this session and get that much done.
May I, Mr. Chairman,
Mrs. Holmes?
before we adjourn, may I give a little thought to our schedule with the commission? We did, in fact, complete our agenda for today. We have scheduled for Wednesday at the evening meeting service areas, and the subcommittee will be meeting to go over service areas at that time. You've been given a copy of also Article 1 and the preamble. Rick, that's your preamble.
I should comment, when we were in the subcommittee,
That's not my preamble.
we all started thinking about the preamble, and we said, well, maybe that's the kind, or at least I, maybe everybody could give a shot at it. This is just my idea of what the type of thing that would be.
What I had planned to suggest today was that each member of the commission, prior to Wednesday's meeting, write a preamble embodying his or her philosophy about the government. I sat down and tried to amend the existing preamble, which doesn't necessarily need amendment at all. We could use the one that's in there. But I think it's an interesting exercise, and we might see some divergent philosophies concerning the charter.
One thing under this, it's something you all ought to think about, that we got 15 years ago when we prepared a preamble that didn't say under God. It was, we got called to task all no ends about it.
No kidding?
Yeah.
Well,
I don't know whether somebody really who felt strongly gathered up the people, but one meeting we after the first publishing of it, we had about 15 people down here talking about the preamble, and all it was whether we want to put under God in it or not.
The office is officially holding a preamble contest that will, your works will be viewed at the board so that everyone can know how we're on this.
When is your work session on the service areas?
we have not scheduled it yet. I'm waiting to see when the council meeting is set up. It has or has not been.
Council
It will be
meeting,
Monday or Tuesday.
I have not been able to get any.
Okay.
And it's Monday on the assembly and Tuesday on the school board?
It's
Right.
Monday on the assembly. Now, Jesse left me a note last night. It said 11 a.m. to 1, but we only have the boardroom from noon to 1:30. And I have not been able to reach Jesse this morning to tell her that. Now, she's contacted some of the other assembly members. So if you run into any assembly members between now and then, tell them it's AMU boardroom and
Do you want me to see if I can change the boardroom time instead?
well,
It depends on if the commission can get there at that time. But you had told me you didn't want it.
I
Okay.
had understood it. 12 to 1.
Yeah.
That's all we can have.
Well, that's all I asked for.
That's all you-
I didn't ask for
Well,
it.
why don't we ask then for 11? Is that all right with you folks?
I just want to know what the decision was. 11 o'clock at the AMU boardroom? Or is it 12 o'clock?
We'll have to.
Why don't we leave it 11 o'clock unless Evie calls us back?
Right. All right, let's leave it 11 o'clock. That won't screw up the details.
Okay.
Individually before we consider it as a commission. If we don't do this,
Which
with this
service
agenda,
area section?
it's listed on your map.
Yeah,
I think Article
read over
9,
what
905.
The old ones?
Yeah, this all relates to the old charter.
Okay. Chairman, I hope that we're speaking to each other by next Saturday evening.
Why?
Because there isn't a day that we don't see each other for a couple of hours. I may be ready to kill all of you by next Saturday.
I tell you, I know.
Tomorrow.
I'm a psychologist who's observing that this is a small, intimate group, and we may be very tired of each other by next Saturday noon.
Jim, I'll always love you. I want you to know that. I'll never
I'm sure that we can find a good psychologist for Saturday afternoon for a little session.
We may need a keg by next Saturday noon.
Mr. Chairman,
Would not be such a bad idea.
it has never been officially said exactly what happens on Tuesday. Do we know that at this time?
Yes.
Oh, I understood it was told.
Maybe everybody knows.
And it's still at the AMU boardroom?
What is it, Mr. Cornett?
School board. The school board at AMU 12 to 1:30.
Now, do you want to change all of those dates to 11 o'clock?
No, because I've already set 12 to 1:30 at the school board.
And, Mr. Chairman, have you discussed in my frequent absences here of late what the meeting is going to be, how the format is? Is it just a general discussion to get their concerns, or was there?
That was my feeling, that what the commission wanted was a general discussion with them to get their concerns and any input they had, and to ask them finally that if they weren't properly heard or if they felt they should put in some written input, we would accept.
I wish you'd had the school board on Monday before I took action on them. Maybe I better not come on Tuesday.
Mr.
Chairman, particularly Dick Fisher asked me, I had set up appointments with the borough attorney and the city attorney on Tuesday. City at 8:30 at his office and the borough at 10. The only time John Spencer could see me was between 8:30 and 10 on Tuesday. I will be there, and I believe Dick will be there, and certainly anyone else who wanted to discuss things along those lines.
8:30 and 10.
8:30 at John Spencer's office for John Spencer.
This Tuesday?
Tuesday, yes ma'am. 10 o'clock at Gary Thurlow's office for Gary Thurlow.
Is this with reference to
Mostly transition matters, I believe.
Mr. Chairman, I did want to point out, intended to, I had some discussion with John Spencer when I was down in Juneau, and John very much wishes to bring his expertise to bear on this, in no way conflicting with you, but as he pointed out, he has been down the road to court and a few other things. And I think that at some point in time, not only on the transitional, but he doesn't want to come before us at a 7:30 meeting and speak in the public. If we could develop, and maybe that's something, Sherry, you could keep in mind, a way that he could review and give input as we go along. We specifically asked, and I think the same with Mr. Thurlow, it might be helpful.
That's good.
Yes, appreciate it very much.
Mr. Chairman,
Mayor Tony?
I think we should request both the city and the borough their financial statements and their budgets for the coming year.
City and the borough. Yeah.
Why? Because some of the information that was given to us yesterday is not backed up in the budget and financial statement of the city.
Where was this?
In relation with our public hearing here Wednesday night. The financial statement and the budget would not necessarily back up some of the statements made. I believe we ought to ask for them.
Well,
Mr.
Mr.
Heavy, I'll ask, but
The bonding or what?
we'll try to get, they're fairly bulky, substantial documents, and if they would be good research material in any case in the office, and I think we should have them for that purpose.
Well, Mr. Chairman, somewhere, and I think that's the responsibility of the transitional group, isn't it? Or perhaps that should be delegated. Somebody needs to get into the whole question of assets and liabilities and bonded indebtedness. Whose responsibility is that?
I had the feeling, and one of the reasons I felt it was so very vital, the transition area, that this is where you're going to have to get into it.
Yeah, but who is?
Well, Dick Fisher has the transition.
Yeah, and he keeps thinking it's no problem, so I'm not sure whether we put it in the right hands.
Right.
Okay, well, I think that's an area that's going to take perhaps a substantial amount of time. I can see asking for these just for a working tool. As a body, we're not going to be able to develop that kind of information.
You arrived on cue.
How about Will the Hudson's group, Frank? Is that helping?
Apparently, from what I can gather, they're not functioning full time.
The only thing is that this whole
Mr. Fisher, we appreciate your coming. We're glad we're able to
committee's going to be able to do it.
We will put you down as being present.
Just barely. We set a time.
Are we
right after the,
We'll be finished in a couple of minutes.
We're finished.
right after
We're finished.
the meeting Monday at AMU?
Okay, and do we have, what are we going to do?
Well, we're going to work on the things that will be considered the rest of the week. Service areas, education, assembly, name, and elections.
Where are you going to
In that order,
Where did she say?
beginning with service areas.
Where would we meet?
I will try and find a place at AMU to meet, a room, or could you?
Or you could always go over to the cafeteria.
You'll be calling them, won't you, about about
It's
the
possible
room?
that we can just stay there. I'll check.
If we can, that would be great, and if they have another room right in that same
For what
building, that would be nice.
That was Monday.
Dick,
Monday. Is that
last night,
subcommittee meeting following the noon meeting with the assembly?
The 11 a.m. meeting tomorrow with the assembly. Unless you're
Sherry,
called.
Sherry, before you get into your service areas, wouldn't it pay for you to get a little bit,
Monday, I'm sorry.
wouldn't it pay for you to get into the transition of these utilities a little bit before you get into the service area so you have a better footing on?
Well, this is a broad statement. If you look at, I think, the article section that's referred to, it's a broad statement about their salary
Oh, it is, okay.
and so forth.
Mr. Chairman, did we set the time for the Saturday meeting and where?
the Saturday meeting
On the
on
5th.
the 5th, no, it has not been set as far as, no, we did set it at 9 a.m. didn't we?
9 till noon.
I think we set it at
Who
9.
was that
But
with?
the location has not been set.
For what?
Work session.
And did you want to ask for the assembly hall?
The point I hadn't thought of. Mr. Fisher, they give you a chance.
Mr. Parsons tells me that the group has sort of decided that spreading of the assets and liabilities is part of transition. You know, is that right?
That was our general
Fine.
feeling.
Okay, no problem. So you
No
want the
problem.
committee.
That's a hell of a
Bill
problem.
Sheffield, where is he?
He was here and gone.
And, hey, I'm sorry I'm late today. I won't tell you, you wouldn't believe it. Well,
Would it be
Bond or
interesting?
brunette?
no, it really wouldn't.
We don't want to know
It
that.
has something to do with opening a bank.
You smiling or not?
I think we ought to start
Shut up,
charging
Reed.
him. Don't you think we should start charging for commercials?
Yeah.
It's getting unbearable.
Hey, Ray, to do that, I really got to have a handle on the finances of the city and the borough. And
Open up your bay.
Yeah. I wanted to say that too.
right now, I'm concerned with the charter. And I really got to do that. And
Evie's going to
just
pick up,
agreed that we would get
we
that.
just agreed that we would have to pick up the borough and the city budgets.
And their financial
no,
statements?
no, but I can't. I mean, I don't feel qualified to do that.
No.
And I don't. Frankly, I don't think anybody else here is. I'd like to get somebody to do that, to really analyze the two. And we talked about that the other day.
It's more than analyzing too, it's also the capital accounts that you have to analyze.
Oh, I know.
It's more,
It's-
just don't stop at the budget.
No, it's a problem.
What is our purpose in this whole thing? Why do we have to become experts?
Because I think to spread the assets and liabilities, we've got to know what the assets and liabilities are.
So we,
We've got to have a handle on it.
first of all, then, we need,
Assets.
Right. You want to know what's going to be the tax base and everything else.
And
before you
from
do
my experience in the matter, you can't look at the budget. I mean, you and I can't pick up the budget and understand what the assets and liabilities and profit and that sort of thing is,
what did
because
you
it's,
do before, Dick?
we had an accountant look into it and give us a report.
And that was the basis of
I
your
promised to
decision.
make I promised to make a contact, and I will do that this afternoon. Given.
Well, if I'm responsible though for it, Mary, or my committee's responsible for it, then our committee ought to do it rather than you.
That's right.
Yeah. Dick,
I said I would be willing to. if you
Dick,
want
the
to.
city has under contract various accounning firms that do this, like Pete Marwick and one. Can't we, on the city's time, borrow these people, have them brief us? Like
Well,
Pete Marwick
the
has
question-
Ernst and Ernst?
Gets to be a problem because if you want to have the same people that are being hired by one of the two entities, because they'll be more protective of the entity than they will
Well,
work for us.
I recognize that, but I think if they could give us a layman's briefing on what they've done to date and how it stands,
Oh, super.
yeah.
Yeah,
I
we're
mean,
going to
that
get that.
Yeah,
And-
that would
and
give
the
us
subcommittee's got that set up
Yeah.
through the finance people of both the city and the borough. So we're going to get that. But I think we need some expertise to look into it.
Right, because we're going to have a problem, because if you get Jack Harris down or any of these people, they're going to be protected, and they're going to slant what they tell us.
Mr. Chairman, I make a motion that the transitional group be requested or asked to look into this matter and come back with a specific recommendation as to the procedure we should follow to get the information needed on assets and liabilities.
There's a motion. Is there a second?
Yes.
Seconded by Mr. Parsons, made by Mrs. Sturgulowski, that the transition committee be authorized to investigate this and come back with a recommendation to the commission as a whole. I don't think it really subject to motion. All those in favor?
Aye.
Aye.
Opposed?
So ordered, a short paper.
Was that adjournment we just voted on?
No, that was the motion.
If there's nothing else, we're 5 minutes over in time of the room. I don't know what the rest of
Thank you. That's not fair, what I'm trying to do.